Hi everyone, this is Priscilla Rader. We're going to get started in about 2 minutes, but to give everyone an opportunity to try out the questions box, which we'll be using during Q&A, if you can just let me know where you're viewing from. I'm in Portland, Oregon, and our speaker, Danny Waltz, is in Washington, D.C. Would love to hear where all of you are from, and we'll get started in just a few minutes. Hello, everyone. Welcome to our first webinar of 2019 under the Animal Law Academy here at the Animal Legal Defense Fund. Thank you so much for taking part of your Friday to join us on a really interesting topic of the Endangered Species Act and how it's helping captive animals. We have the fabulous staff attorney for the Animal Legal Defense Fund, Danny Waltz, with us. As staff attorney for the Animal Legal Defense Fund, Danny develops creative legal strategies to advocate for improved welfare and increased protections for animals. Danny first worked with the Animal Legal Defense Fund as a litigation fellow from 2012 to 2014 when he participated in Cole v. Selmer, which eventually set a legal precedent to protect endangered animals in captivity. This is the Cricket Hollow Zoo case that I imagine many of you are familiar with. So Danny worked on that as a litigation fellow. He then went on to spend 2 years at Georgetown University Law Center's Environmental Law Clinic and 2 years as a staff attorney for the Humane Society of the United States before returning to us here at the Animal Legal Defense Fund as a staff attorney here now. We're really happy to have him back, and he'll be walking through some of our the Cricket Hollow Zoo case and then the subsequent cases that have followed since that victory. So please join me in welcoming Danny Waltz wherever you are, and thanks again for joining us. Danny, it's your show now.
Thanks, Priscilla.
Yeah.
And hi, everyone. So as Priscilla mentioned, that I've returned to ALDF, and because I'm a member of Animal Legal Defense Fund's litigation team and very proud of it, I thought I'd start with a brief overview of our litigation group and what we aim to do to fulfill ALDF's mission. And then move on to give an in-depth overview, introduction of the star of today's show, the Endangered Species Act, or ESA for shorthand. And once we have a basic understanding of how the ESA operates, I'll then move to discuss how we can apply it to protect animals with a particular focus on animals in captivity. We'll then end with an opportunity for question and answer. I'll try to leave some space for that because I've already received a number of questions in advance of this webinar. And my experience has been in fora like this, that what people bring up with questions or just reactions to the subject matter often leads to creative new strategies, which we then apply in our work, sort of hive mind. So today's the framing that I want to use today is that the ESA is a pit bull of environmental laws.
Oh, do you want to share your screen?
Yes. Oh, I'm not doing that.
Thanks, Dan.
Sure. Okay. Crystal, things are good? Okay.
Perfect.
All right. So a quick but necessary disclaimer. What I say here is my own opinion and not necessarily that of the Animal Legal Defense Fund or anyone who we represent in either human, organization, or non-human animal form. I'm sure some of our animal clients have a lot of opinions that may disagree with mine. So first, a bit about ALDF and our litigation program. As many folks know, ALDF is a growing organization with a number of programs from legal education to criminal law. And the litigation program has been a central part of ALDF from very early on. It too is growing. When I was a fellow, we only had a few attorneys. Now our staff comprises 7 staff attorneys, including our litigation director, and 3 1- to 2-year litigation fellows. We try to team up on all of our cases. I'm actually showing you a photo of my co-counsel, Tippy. He lives with me in Washington, D.C., and he's admitted to the Washington, D.C. bar. Sorry, lame joke. We also have a constant stream of law school clerks, both during the summer and during the semester terms. I mention this because I suspect that there are a number of law students watching right now, and I would encourage you to check out our website regularly to consider putting your legal education work into one of our open positions to advocate for animals. Our litigation team also works with a large number of law firms and attorneys on a pro bono basis. We, in fact, have a full-time attorney who works as our pro bono liaison. And I mention this because there may be some private attorneys who are watching. And I'd encourage, if you are one, I'd encourage you to connect with us about assisting pro bono on any of our cutting-edge animal law cases, especially our Endangered Species Act cases. Those are very time-consuming and resource-intensive. And finally, since I'm doing a good bit of encouraging here, a bit more wouldn't hurt. I bet I'm preaching to the choir, but I would encourage everyone who's watching to take the next step to become a vegetarian or a vegan or adopt a plant-based lifestyle, or whatever the cool term is now. Just to take an example from fairly recent events, if we stopped relying on industrial animal agriculture, then the hurricanes that recently passed through North Carolina and Virginia, near where I live, would not have drowned or caused starvation of hundreds of thousands of pigs and millions of birds. And their manure wouldn't be threatening communities that live near the factory farms near where I live. Okay, enough proselytizing. So just to describe a few of our goals within the litigation program, best place to start would be our mission. We aim to protect the lives and advance the interests of animals through the legal system. So the 2 aspects of this mission drive the majority of our litigation cases. We both look to improve individual animal welfare, that would be the protect the lives aspect, and set precedent that provides for more legal rights and legal protected interests for non-human animals. That would be advancing the interests of animals. So for example, the constitutional challenges that we make to the ag-gag laws can be seen to achieve both the improving animal welfare and setting precedent aspects. You can see that, one can look at those cases as demonstrating that the Constitution provides the right to expose the horrific conditions of factory farming, giving voice through the legal system to suffering animals. And then those challenges also have the effect of leading to industry changes. which can, at the very minimum, cause retailers to cut contracts with abusive suppliers and hence protect the lives of animals. We are also focusing on, through our cases, paving the way for civil causes of action to enforce state animal cruelty laws, or to stop abusers from engaging in violations of state animal cruelty laws. These, again, balance the twin pursuits of our mission of setting precedent to expand animals' legal interests, but also to improve animal welfare. The case I'm showing you here is our lawsuit in Oregon on behalf of Justice the horse, who's seeking restitution for animal cruelty violations. And we're suing in his own name, where he's his own plaintiff. So the Endangered Species Act cases that we bring on behalf of animals, in particular on behalf of animals held in captivity, I think can be seen as a form of even these civil causes of action to enforce state animal cruelty laws. Even though the Endangered Species Act is a federal law, the ESA prohibits activities that one would undertake against endangered animals that are often the same or similar activities that states would view as animal cruelty. And the Endangered Species Act gives your private citizen an avenue to bring a civil lawsuit to enforce its protections. But I'm getting ahead of myself. So let's start by jumping into the text of the Endangered Species Act, because that's the good stuff that we're all here for. Okay, so the Endangered Species Act is one of our strongest environmental laws. Legal scholars have called it the quote-unquote pit bull of federal environmental legislation. Tippy, my Chihuahua wiener dog, I think would be offended that pit bulls get all the credit for this powerful metaphor, but I think it, I think it resonates in terms of the powerful grip that the ESA has on once a violation occurs and courts can actually enjoin the activity or stop the activity. So to give an example of the Endangered Species Act strength, consider the Tellico Dam. This is the black and white photo here. It was a multi-million-dollar dam in Tennessee. Congress had appropriated millions of dollars multiple times in the 1970s to create the dam. It was nearly done by the time a law professor from the University of Tennessee, Zygmunt Plater, discovered with his students the snail darter. This is the photo on the left. The snail darter, not much bigger than a paperclip, stopped the dam in its tracks. The endangered species, it did so by, through the Endangered Species Act. The law, which really had not been around for very long, it was really hitting puberty and wasn't aware of its own strength, made its way, was the focus of the citizen lawsuit, and made its way all the way up to the Supreme Court, where the Supreme Court found that the construction of the dam, if it had been fully completed, would have modified the habitat of the snail darter to such an extent that the fish wouldn't have been able to survive and would have gone extinct. So the Supreme Court, for that reason, stopped the final construction of the dam, and it, I believe, it doesn't exist today. The backstory about this opinion, though, is that it was actually written by a fairly conservative justice, Chief Justice Berger, who some believe he wrote the opinion very aggressively to show almost with exaggeration how powerful the law was to encourage Congress to go back and gut some of the stronger provisions. With the idea that Congress would look at this decision and say, oh my God, if this is stopping a multi-million-dollar dam, this law is achieving much more than we intended it to do. and so we need to scale it back. However, Congress really hasn't scaled it back. Occasionally, Congress steps in and may make some tweaks to the ESA, for example, delisting a certain species, but hasn't done anything to the extent that Chief Justice Berger was envisioning. Okay, let's move into some key provisions of the Endangered Species Act. The first is Section 11. This is the citizen suit provision. It is certainly a part of the Endangered Species Act's strength is that its determination or its allocation of who gets to enforce the law. It allows private attorneys general to bring suit for violations of the act, assuming that they can meet some other criteria to get into court. There isn't this reliance on the government to prosecute the ESA or to bring the lawsuit. So if everyone can take a few seconds to think about why the citizen suit provision would make the Endangered Species Act so powerful. Just sort of brainstorm. I'll throw out a few different ideas for why I think the citizen suit provision is really key to the statute. What it first does is it removes the government's enforcement discretion, such that citizens are the decision makers of when to bring a lawsuit, not just the federal government. So this avoids the government saying that they have limited resources. So think, for example, the Trump administration recently declaring an emergency and moving money away from other programs to build the wall, and now may not have money, may claim to not have enough money to bring an Endangered Species Act lawsuit. Another reason there's value in removing agency enforcement discretion is it avoids agencies having policy or precedent concerns. An example of this might be when I was a law student during my summer internship, I worked for a law firm that had sued a golf course to protect the California red-legged frog. This was a threatened species protected by the Endangered Species Act, and that frog was being harmed by the golf course or taken by the golf course because its tadpoles and eggs were being sucked through a water hazard. Why might an agency have concerns about this precedent here? Again, I would think about the Trump administration potentially not wanting to show that the Endangered Species Act could stop the operation and construction of golf courses. And a third option a third reason for why I think removing the government's enforcement discretion strengthens the ESA is it avoids agency capture. So think, for example, the new secretary or acting secretary of the Interior had previously been an oil and gas lobbyist. If the Interior Department, who enforces the Endangered Species Act, was confronted with a fact pattern showing that oil and gas extraction was harming an endangered animal or a listed animal, for example, the sage grouse in Colorado, they may not have the incentive because of the sort of revolving door between industry and the government. In addition to removing agency enforcement discretion, a citizen supervision also allows the Endangered Species Act to take advantage of the increased information from people who are living nearby and on the ground. Neighbors, residents, where violations of the Endangered Species Act are occurring, may be more familiar with the animals and how the animals are who are being harmed, how they're being harmed. This also encourages the creation of backyard environmentalists and may make more people like you and me be excited about the Endangered Species Act and be excited about the wonder at the nature around them. And finally, I think the citizen supervision makes the Endangered Species Act powerful because it puts potential defendants, private actors and government actors who are conducting activities that could harm endangered species, puts them on notice that anyone can go after them. And knowing that, not only if you're violating the law, not only do you have to worry about Uncle Sam watching you, but you also have to worry about your neighbor can whip you into shape and comply with the law. The downside of this, though, would be that this can actually motivate people to hide their violations of the Endangered Species Act. What's called in the literature the shoot, shovel, and shut up response to the Endangered Species Act. If a landowner discovers a member of an endangered species on the property that he or she is planning to change in some way or another, in a way that could harm that species, they may just shoot, shovel, and bury the animal and then shut up about it. So along with the citizen supervision, there are 3 other sections of the Endangered Species Act that are key to how the law operates. The second provision is Section 9. This is known as the take prohibition, or the take provision. It prohibits private actors and the government from taking or harassing, harming, wounding animals who are members of species that are endangered or threatened on the endangered species list. This provision was made most famous by a Supreme Court case that you may be familiar with called Babbitt v. Sweet Home, Chapter of Communities for a Great Oregon. In this case, timber companies in the housing industry had challenged government's determination that logging would violate the Endangered Species Act by harming an endangered woodpecker. The issue was whether the logging, which wouldn't directly kill the birds, would still harm them because it would modify the habitat in such a way that even if the woodpecker wasn't in the tree, his habitat would be eliminated. He wouldn't be able to survive and reproduce. The decision, the Supreme Court decision, was hotly contested with some of the, I would say, the most famous justices for their statutory interpretation going at it. Justice Stevens with the winning opinion, and Justice Scalia in the dissent, which I'd like to describe the various approaches to interpreting the take provision was like a wedding floor dance-off, where each justice had his own moves that tried to get the rest of the crowd to dance along with him, each having a different type of move. Justice Stevens eventually won with his form of interpreting the statute, with the outcome being that activities that are even indirectly harm the woodpecker or indirectly harm members of endangered species violate the Endangered Species Act. So, for example, the court held that the draining of a pond, if one knows that there are endangered fish in the pond, even if that doesn't directly, even if you're not directly shooting the fish, because you're draining the pond, you're violating the Endangered Species Act. We're going to return to this definition in particular, the definition of take, later on, because it's the key provision for protecting captive animals. But I'd like to actually first give a few examples of how take of endangered animals can occur. I've already described the sucking of frog eggs through a water hazard. But also, wind courts have found that the construction of a wind farm can take endangered birds and bats by killing them as they're so bats, for example, can't recognize the rotating wind turbines with their radar and can be killed. And even a court has recently found that even the taking of photos of a sleeping manatee can be a take, in that it risks harassing and harming an individual animal that is covered by either the Endangered Species Act or the Marine Mammals Protection Act, which uses the same take language. So now there are two important defenses to the take prohibition. For the prohibition on taking individual members of species. The first is the incidental take permit. A private actor who knows that his otherwise lawful activity could, by incidentally, so somewhat by accident, take an endangered or threatened animal, can get a permit to, so long as the other activity is lawful, can get a permit to incidentally take those animals. To get the permit, the private actor needs to have an approved mitigation plan called a habitat conservation plan. So for example, if a wind utility is building a wind farm, knows that it might be killing some endangered animals, some birds or bats, that wind company can set aside some land through a habitat conservation plan that should help mitigate the loss of the species. The other big defense out there is called proximate cause. The best way to describe this defense would be through a case, this Fifth Circuit case, that showed how it can be a stumbling block for Endangered Species Act protections. So the entire, it concerns the whooping crane. The entire endangered whooping crane population exists in one flock, which spends its winters in Aransas National Refuge in Texas. And in 2008, 2009, the flock lost a large number of its members. Advocacy groups, including the Aransas Project, brought a lawsuit against Texas, which they claimed Texas's Department of Environmental Quality, which regulates the diversion of water quality, had diverted water for other uses that limited the amount of fresh water that came into the refuge where whooping cranes winter. This in turn led to emaciated and dying cranes. The Fifth Circuit found that the citizen suit that Aransas Project brought couldn't succeed because the proximate cause was too attenuated. The judges said that Texas's issuance of water withdrawal permits, that was the action that Texas took, even if that led to the decline of inflows of fresh water to the refuge, which then increased the refuge's salinity, so the salt water was, there was higher salinity with more salt water and less fresh water. This in turn reduced the principal food sources for crabs, which reduced the crab population, which were the diets for the cranes, and that's what caused the food stress and emaciation. Even if all of those steps, even if all that was true, it was just too attenuated. It wasn't, in the court's words, foreseeable for Texas to have harmed the birds through its diversion of water. The number of links in the chain were too many. I can see how the court points out there were a number of links in the chain, but you know, how this is different from Justice Stevens' example of draining a pond that could kill fish in Babbitt v. Sweet Home, the Supreme Court case I just spoke about. That's beyond me. I can't, to me, they seem very similar to each other, and I think the Fifth Circuit wrongly decided the case, but unfortunately, at least in the Fifth Circuit, that is the law now. Okay, so we've talked about Section 11 and Section 9. The third key Endangered Species Act provision is the jeopardy provision. This regulates federal agencies. It's not directly on point for private possession of captive animals, so I'll quickly run through it. What this jeopardy provision does is it imposes two twin restrictions on federal agencies. It says that an agency cannot take an action that otherwise, or that would jeopardize a species survival. So for example, when the U.S. Department of Transportation creates a highway, it must first consult with the Fish and Wildlife Service, who is the agency that has been granted authority under the Endangered Species Act to be the expert agency for determining whether an action could jeopardize a species. The U.S. Department of Transportation will consult with the Fish and Wildlife Service, and if the Fish and Wildlife Service thinks that there is that the action will jeopardize the continued existence of a species, the agency, the U.S. Department of Transportation, must either find an alternative approach to take, alternative action, or stop work completely, or even mitigate, sort of reduce the size of its project. The other option that the agency could do, the U.S. Department of Transportation could do, is to try to persuade a committee that's informally called the God Squad, persuade the committee to approve the construction of the project, even if it were to jeopardize or make species go extinct, which is why it's called the God Squad. The second restriction that Section 7 places on agencies is that an agency like the Department of Transportation cannot take an action that will adversely modify or destroy critical habitat. So it both can't jeopardize a species population, but also it can't adversely modify or jeopardize, in a sense, the habitat for the species. Critical habitat is a term of art under the Endangered Species Act. It is the habitat that gets designated, that should be designated at the same time a species is listed under the ESA, which is a good segue for the fourth and final key provision that I'd like to talk about. We've been going from the bottom to now we're here, and that is Section 4 of the ESA. This is the listing provision. So the Fish and Wildlife Service, which is a designated expert agency under the Endangered Species Act, as applied to land animals, and the National Marine Fisheries Service, which is the expert agency as applied to marine animals, are the two agencies that determine whether a species should be listed to be protected under the Endangered Species Act. And to be protected, a species is either listed as endangered or threatened. Those agencies can make the determination to list the species on their own or in response to a petition from the public. The listing decision-making process takes several steps. This includes an initial finding, and then a more in-depth finding, and then final rule. The statute lays out several factors that an agency must consider, including the species habitat or range, how those members of the species are being quote-unquote utilized or exploited, and other regulatory mechanisms. Notably, these agencies, when they make a listing determination, can only consider scientific information and are not supposed to consider economic consequences. So members of the public can submit petitions to list a species, and the federal government often responds to these petitions in three ways. It either says that a species should be listed, that the protections are warranted. It can also respond by saying that protections are not warranted, or as we're seeing more and more happening, it can say that protections are warranted but precluded, that the agency doesn't have the resources to go through the listing process. And so it puts species on a waiting list. This is sort of like when the storm creating the flood starts. If Noah said, okay, animals, you should be on the ark, but it's full right now, so why don't you just wait here and let me sail around and find some more wood to expand my boat, and I'll come back when I can. That's kind of what the agency is saying. There's been a lot of litigation over these listing decisions. Not sure why that's the case. My guess is for why we see a lot of litigation over this is because the massive protections of the Endangered Species Act only take place once a species is listed. If you're not listed, you don't get any of the protections. So the best way to both say a species is proposed to be listed, if you're an industry that is taking a large number of these animals, where it's currently not against the law to do so, but it would be if they become listed, you would definitely litigate to stop that the listing from happening. We're also seeing a lot of scientific research concerning extinctions and the 6 extinctions. So with more science out there and the requirement that agencies need to be basing their decisions on the best available science, we'll see more and more use of that science in the form of petitions and litigation over the petitions. Okay, so those are the 4 key provisions that I think were necessary primer for jumping into how the Endangered Species Act is applied. I do want to very briefly just touch on, though, that the ESA, while it is known as the pit bull and is very powerful, it does have limitations. As I just mentioned, the law doesn't protect animals that aren't listed as endangered or threatened. And even for those who are listed, there are some problems that are just too big for the Endangered Species Act to handle. I guess a better way to put it is that federal agencies and courts are unwilling to use this law to try to regulate the country writ large. So a couple examples here. Just earlier this week, the Washington Post reported on the Bramble Cay melomys. I'm sure I'm mispronouncing that. But that is a rat-like rodent that was native to an island in Australia. This is the first mammal who has been identified as having gone extinct because of global warming. And we haven't really seen yet how, if at all, the Endangered Species Act can tackle climate change. In what seemed like a pretty good step, the Ninth Circuit allowed the Fish and Wildlife Service to set aside land as critical habitats to protect certain parts of Alaska for polar bears, where there weren't any polar bears that were currently living because of the expectation that they would be moving there with global warming. That seemed like a positive step, yet just this year, earlier this term, the Supreme Court, in a case concerning the dusky gopher frog that was living in some tide pools in, I think, a southern state, could potentially live in habitat in pools in a southern state, but weren't currently there. The court suggested that the agency may not designate as critical habitat parts or areas where the animal is not currently living, which at least calls to question the Ninth Circuit's polar bear decision. I want to include this somber note because I think identifying the problem and not just the satisfying wins, which I'm going to jump into very shortly, can help motivate us to be better advocates for stronger laws and to push for legislative change. But we're learning that the Endangered Species Act can be used to protect animals in captivity, so I want to turn to that. At an abstract level, I want to just highlight two different lenses for thinking about the problems with captivity. These concepts are best shown through examples, but you can identify the problems within the animal rights lens and the animal welfare lens. The rights lens being a denial of one's right to autonomy. If you're captive, you can't make decisions that you would be able to make in the wild, and also the communal rights of being able to flourish in a wild community in a natural environment with others. The captivity imposes an artificial community, or maybe no community whatsoever. And then from a welfare perspective, conditions of captivity can pose a wide variety of problems, as we'll see, which can include inadequate food, water, shelter, inadequate veterinary care, and frustrations of one's instincts or psychological needs. An animal doesn't have the opportunity to act as he or she would expect or would otherwise plan to within the economy, within sort of the framework of its species needs. All right, so to have I kind of want to talk about the path that we followed to get the Endangered Species Act to provide protections to captive animals. The first step was to get decision makers to even acknowledge that the Endangered Species Act applies to captive animals. It's hard to believe, but not very long ago, like less than 10 years ago, the federal government took the position that the Endangered Species Act only applied or could have stronger protections for animals in the wild than it would to the same members of the same species in captivity. So, for example, chimpanzees were listed as endangered in the wild, but were not endangered if they were held in laboratories and used for experimentation. So to pave the way for the Endangered Species Act to protect animals at, say, roadside zoos, we had to first persuade agencies and subsequently courts that Congress didn't intend to make this distinction between wild and captive animals, and that the ESA applied to, if you were a member of a listed species, the ESA applied to you no matter where you were living. So a couple of successes I want to highlight here in a number of rulemakings between 2013 and 2015. The Obama administration determined that there wasn't a difference or a meaningful difference between wild and captive populations in how they should be treated under the Endangered Species Act. These rulemakings mostly came about in the context of chimpanzees in captivity. I just wanted to highlight here this website called The Last 1000, which is run by Professor Lori Gruen of Wesleyan University. She's tracking all of the chimpanzees that were held in laboratories and used in experimentation and their slow but steady movement to sanctuary. It's a fun website to follow. Another success, I think we can call it success, was the National Marine Fisheries Service decision that Lolita, the orca held in captivity at the Miami Seaquarium, and this is a photo of Lolita in her, for lack of a better term, fish tank. The Marine Fisheries Service found that she was endangered, just like the rest of her family, who continues to live in the Puget Sound. It's kind of shocking to me that she wasn't listed, but she wasn't. That decision happened maybe 3 to 4 years ago. So step two, the next step, was to figure out who could bring a lawsuit to protect animal welfare. As I mentioned, Section 11 of the Endangered Species Act provides for a citizen supervision, which what it does is it authorizes a cause of action against private actors and the government for violating the Endangered Species Act. But a cause of action isn't all that's needed to get into the courthouse doors. According to the Supreme Court, the U.S. Constitution, through these three words, the words cases or controversies, imposes additional requirements, form of gatekeeping, so that courts aren't inundated with lawsuits that aren't true, quote unquote, cases or controversies. This is called, the doctrine here is called standing, that the plaintiff needs to have standing to bring a lawsuit in addition to the citizen supervision. And to have standing, a plaintiff needs to prove three elements to get the case heard. Injury in fact, that one is injured. Causation, that the injury is caused by the defendant. And redressability, that the court, if the court makes a favorable decision for the plaintiff, the court would redress the injury. So just like with the distinction between captive and wild populations, it wasn't so long ago that it was completely unheard of for someone to bring a civil lawsuit to protect the well-being of an individual animal. So sure, for decades now, we've had environmental cases where someone could say that they like to hike in an area where they saw, for example, a bunch of eagles, and then could sue over whatever activity has reduced the amount of eagles in the area, reducing the opportunities to view the eagles. But that was as close as we've gotten. I really like to point out this case, Animal Legal Defense Fund v. Glickman, because it was not only paradigm shifting, but also is a case commonly seen in case law books, law student case books, where the court decided the DC Circuit, in an opinion by Judge Patricia Wald, who's shown getting a medal from President Obama, she decided that one could sue for would have injury in fact and have standing for continuing to view an animal who is suffering in captivity, even if that animal doesn't die and you lose the opportunity to view that animal. So the ongoing viewing of an animal in inhumane or terrible conditions could give rise to standing. In Glickman, the plaintiff, Mark Jernoff, his photo is shown here, was a wildlife rehabilitator who made repeated visits to the Long Island Game Farm where he saw primates in dilapidated conditions. Judge Wald held that Jernoff had alleged a sufficient injury caused by the Long Island Game Farm and that could be solved or resolved or redressed by a favorable decision from the court. We call this now, this for shorthand, the industry term we use is aesthetic injury or aesthetic standing. One's aesthetic interest in the humane conditions of an animal suffices for, if impeded, could create injury. That aesthetic injury has been continued to be applied to roadside zoos. We've put this precedent to good use in Hill v. Coggins, where two members of the Cherokee tribe sued the Cherokee Bear Zoo in North Carolina, which was keeping grizzlies in gladiator-style bear pits with bears begging for food. The district court, affirmed by the Fourth Circuit, found that even though these two members of the Cherokee tribe visited the bear pits for no more than 30 minutes total, the aesthetic connection and relationship that they developed with the bears and harm by seeing these bears suffering sufficed for injury in fact and for standing to bring the lawsuit. This isn't to say, though, that standing in these cases is easy to show. I want you to be wary of, in particular, the Ringling Brothers case or the Feld case. And I'm just noticing now that all my photos of the animals in these cases are of them standing. I didn't really mean that pun, but that's funny. It reminds me of a joke that I heard from an old mentor who's now retired, who said that he couldn't wait for courts to decide that animals themselves had standing so that we wouldn't have to rely on the whims of a human plaintiff. Actually, LDF is making its way there with the justice case that I presented earlier as an attempt to give animals standing. So in the Feld case, the plaintiff was an elephant handler or an elephant barn hand for Ringling Brothers. His name was Tom Ryder. He had claimed to develop the relationship with the elephants under his care, and that he was upset about the abusive practices he was forced to inflict and what he saw that he witnessed other trainers inflict, including using bull hooks against the elephants. But the case made it to trial, and his testimony at trial caused the district court to decide that he didn't have standing, that he was too inconsistent. It came out that he had actually used bull hooks later on when he was working for a different circus. And there was footage of him swearing at elephants. It also came out that he couldn't remember which elephant was which when presented with photos. So the court granted judgment to Ringling Brothers and then made the plaintiffs pay attorney's fees for the defendants. It was a very tough case and tough time for the animal movement. But while this case had a pretty terrible immediate outcome, particularly with regard to standing, it gave, I'd say it gave animal advocates within the movement a glimpse of what the ESA could offer. And, you know, just to quickly note, thanks to the tireless efforts from groups like ALDF and PETA and the Humane Society and the ASPCA, Ringling Brothers no longer uses elephants in its circus shows. But we saw that the theory of the Endangered Species Act, at least on the merits, not as applied to standing, but on the merits, was sound. That the circus's practices against the elephants could, in fact, violate the Section 9, the take prohibition under the Endangered Species Act. Even the circus's lawyer admitted that the use of bull hooks, if they broke the elephant's skin, would constitute a wound, which is one of the definitions of take prohibited by Section 9. So with the ESA applying to captive animals and standing, they're now being aesthetic standing to bring a lawsuit, everything culminated in success with the Cricket Hollow Zoo case, captioned Keel v. Sellner. The facts of this case, I think it's helpful to describe the facts of the case. So this is a roadside zoo. Cricket Hollow Zoo is a roadside zoo depicted in this photo here in Manchester, Iowa, a small town in Iowa. At one point in time, it had over 300 animals, many of which were exotic animals. As a roadside zoo, it was an exhibitor. It exhibited animals, which meant that it was regulated by the U.S. Department of Agriculture under the Animal Welfare Act. And over the past decade leading up to this lawsuit, so I guess now over the past 15 years, the U.S. Department of Agriculture issued several citations and warnings to the Cricket Hollow Zoo for violations of the Animal Welfare Act. With them in emails to each other, the top officials at the USDA in emails to each other, referring to the zoo owners as chronic violators who are either unfit or unwilling to meet the standards of the Animal Welfare Act. We learned this through our Freedom of Information Act requests. So how did the lawsuit come to being? Animal Legal Defense Fund connected up with several individual plaintiffs, all of whom had visited Cricket Hollow Zoo several times over the previous years. And I'm smiling because it brings back warm memories. When I was a fellow, what caught our attention was that a local paper had reported on how these individuals who visited the zoo had been really expressing their concerns for the animals at Cricket Hollow, and taking photos, video, and this led the zoo to informally prohibit the use of cameras and video. And I remember our interest was first piqued at the potential First Amendment issues that were raised, but as we looked further into the case and talked with the individuals who eventually became plaintiffs, there were a number of other claims available, especially the Endangered Species Act. So two of the individuals are people I want to briefly focus on. They're the sisters Tracy and Lisa Keel. They grew up on a farm together and both went on to illustrious careers. One is the director of a museum and the other is a pilot. And actually thinking back on it, I think the experience of both of them with their careers prepared them well for their advocacy on behalf of the animals at the zoo. With Tracy's museum experience, thinking about how to provide an experience for visitors that doesn't create aesthetic harm, and Lisa flying over the zoo to witness what exactly it looked like, to get a full picture of what Cricket Hollow Zoo looked like. I think importantly, neither Tracy nor Lisa was, or as far as I know now, is anti-zoo. And yet they were still shocked by what they saw at Cricket Hollow Zoo. They went into advocacy mode and asked all sorts of officials to step in and stop the zoo from harming its animals. By the time we linked up with them and resorted to litigation, I believe that every official in Iowa and Senator Chuck Grassley had heard from Tracy and Lisa about the Cricket Hollow Zoo. And this was very useful because standing became a central aspect of the zoo's defense. All of the individual plaintiffs sat through depositions and testified at trial. It's important to know that can happen. It's something to think about when you bring these cases. If you bring them on behalf of individuals, I think one should prepare them to know that they're really going to be put through the ringer. And so it helps, as their lawyer, it helps to do your homework, make sure that they know what they're going to be up against, and that they are, passionate for the lawsuit. Without that passion, it may be harder to demonstrate standing. Eventually, the district court found that all of the individuals had standing. Judge Scholes of the Northern District of Iowa found that Tracy and Lisa Keel and the other individuals had an aesthetic interest in the endangered animals that were living in inhumane conditions, very similar to Mark Jernov and Glickman, and that the individuals would go back to the zoo if the living conditions for the animals improved, or if the animals were transferred to a place with humane conditions. I think that the court's finding here is a big deal because while the Keel sisters and their fellow individual plaintiffs are heroes for the animals at Cricket Hollow Zoo, they'll be the first to tell you that they're not unusual in terms of their advocacy for animals. This country is chock full of people who are shocked and upset by inhumane conditions that they see when they visit a roadside zoo. And with the framework laid out by a very rigorous decision by the Northern District of Iowa, other individuals can follow up and demonstrate standing to bring an Endangered Species Act. So while overcoming standing was important, it was important because it really all left for us to do was to prove the merits of the case, which was that Cricket Hollow Zoo is violating the take prohibition of Section 9 of the Endangered Species Act. So how to show take? I'm gonna have to take a legal interlude here and dive into the regulatory definitions of take to show how we proved the violations at Cricket Hollow Zoo. So there are as I mentioned, there are several sub-definitions of take, but the two we would like to focus on are harass and harm. When applied to animals in captivity, these are the two most relevant terms. And the Fish and Wildlife Service has interpreted both of the terms. So the sentences starting with harm and harass are the Fish and Wildlife Service's regulations with the definitions. You can read both, so I'd like to just focus on harass. I find that the most interesting. What the Fish and Wildlife Service definition is doing here is it's saying that you're violating the Endangered Species Act if your activities annoy the animal to such an extent that it impedes the normal behavior patterns, the normal behaviors of breeding, feeding, or sheltering. I really like this definition because it suggests that different species breed, feed, and shelter in different ways. It allows courts to sort of assess how different animals have different species-based individualized needs, and then consider how the Endangered Species Act can protect those needs. It gives those individual animals a sense of their own autonomy in their own species-specific way. And so, in the captive context, the Fish and Wildlife Service creates an exemption. The exemption is for any generally accepted animal husbandry practices that meet the minimum standards of a different statute, the Animal Welfare Act. If all of those elements are met, then this is not even annoying an animal to the extent that it impedes the normal behavioral patterns, would not be a violation of the Endangered Species Act, would not be harassment of the animal. This exemption, I read this, thinking about this exemption, I read this to sort of operate as follows. The plaintiff must show that the defendant is taking an action that interferes with normal behavior patterns. And then after that initial showing, the defendant, to take advantage of the exemption, must show that it is keeping the animal in a way that is both generally accepted and equal to or above the minimum standards of the Animal Welfare Act. This can get a little complicated because of the interplay with another federal statute. So the Animal Welfare Act does not cover certain species like birds and reptiles that are listed as endangered. What happens if there is a captive, if say Cricket Hollow Zoo kept captive endangered birds? How would the exemption apply there? There wouldn't be any minimum standards of the Animal Welfare Act for the zoo to exceed or fall short of. And then when you're trying to figure out whether husbandry practices meet or exceed those standards of care, who gets deference? Let's say the Fish and Wildlife Service and the U.S. Department of Agriculture have two different opinions about whether the minimum standards are met. Whose opinion matters to the court? or receives more weight. I'm not sure, no courts have dealt with these questions yet, but they could in the future. So to apply these definitions and exemptions to the Cricket Hollow Zoo case, I want to show you some of the evidence that the Animal Legal Defense Fund plaintiffs used. The first is that we showed that the veterinarian for Cricket Hollow Zoo admitted that he wasn't, quote unquote, a big monkey person, which in and of itself demonstrated a lot, considering that the endangered species at the zoo were lemurs and not monkeys. Also, the sheet on the right-hand side shows the veterinarian bills for Cricket Hollow Zoo, and it showed that over 8 years, the bills summed less than $7,000. Animal Legal Defense Fund's experts in this case showed at trial that each of the 300 animals at the zoo should have cost at least $1,000 in veterinary care per year. And so $7,000 over 8 years was far, far short of adequate veterinary care. Other evidence was ALDF used some very powerful experts. One such expert was Dr. Peter Klopfer. He's a renowned lemur expert at the Duke Lemur Center. He opined on the sanitation of the lemur enclosures and the social isolation there were 2 lemurs kept in social isolation at Cricket Hollow Zoo, and made some very powerful testimony where he essentially said that lemurs it was as if they were living in a phone booth by themselves. I'll say that the advantage of Endangered Species Act cases versus other types of cases, for example, farm animal welfare cases that I also bring, is that the animal welfare experts are a bit easier to find in the Endangered Species Act conference. Those experts who do research on exotic animals are not as tied up with the industry as, say, farm animal experts, who are more often from ag schools who have received grants from large corporations that engage in factory farming. So that one has the ability to find a Dr. Peter Klopfer in the Endangered Species Act context. Other evidence that we used were the U.S. inspection reports from the U.S. Department of Agriculture. These are inspection reports from Animal Welfare Act inspections. If you think about the harass exemption, and we needed to show that that the zoo was keeping endangered animals in conditions that were below the minimum standards of the Animal Welfare Act, one of the best ways to show that the zoo wasn't meeting the Animal Welfare Act standards were the inspection reports. This was a nifty chart put together that shows all of the various Animal Welfare Act violations as applied to the endangered animals. So, for example, feces and sanitation, these are columns show just the unclean enclosures for the lemurs and the tigers, who are the endangered animals at issue in this case. The result of the lawsuit after trial was that the district court found the zoo to be violating the Endangered Species Act as applied to tigers and lemurs. So for tigers, the court found that the zoo had failed to provide proper veterinary care, allowing tigers to fall ill and die without veterinary care, or even to perform a necropsy to figure out what went wrong. And also failing to remove excessive feces, which created a disease hazard. The district court also found that the zoo had harassed the lemurs by housing them in social isolation. This was inconsistent with their species' social needs because they were a troop species and disrupted their normal behavioral pattern. Note that these were standards that were tied to the Animal Welfare Act, so the court found the conditions there fell short of the standards, which I think goes to show that the inspection reports really worked wonders on the judge. That said, I don't think that a violation of the Endangered Species Act has to be so tied to Animal Welfare Act standards. So, as I mentioned, the Animal Welfare Act doesn't have standards for birds or for reptiles, which means that if a zoo happens to be keeping an animal, a bird, an endangered bird, and there aren't Animal Welfare Act standards that apply to the bird, I don't think the exemption itself should apply. Whatever, the question is just, are the conditions creating a likelihood of injury by annoying the animal to such an extent as to disrupt the normal behavioral patterns? The other aspect of the exemption that could suggest that the Animal Welfare Act doesn't apply at all would be in situations where there aren't generally accepted husbandry practices taking place. So, for example, the Cherokee Bear Zoo's bear pits, which a court has found to be "quote unquote" archaic, are, in my view, not generally accepted husbandry practices. And so, even if the U.S. Department of Agriculture found that the minimum standards of the Animal Welfare Act are being met, the exemption still can't apply because the bears are being kept in such conditions that aren't generally accepted. After the district court's decision in Cricket Hollow Zoo appealed to the 8th Circuit. And just last year, right after, I think like a week after I returned to Animal Legal Defense Fund, the Court of Appeals affirmed the district court's decision. They found that the plaintiffs, individual plaintiffs and Animal Legal Defense Fund had standing, and that the zoo had violated the Endangered Species Act. I think this shows the cross-cutting nature politically of animal protection issues. All of the judges on that 8th Circuit panel were appointees from Republican presidents. Yet they applied a law that had been helped along by the Obama administration in its rulemakings, applying it to captivity. The one aspect of that of the 8th Circuit's decision, though, which actually also appeared in the district court decision that wasn't entirely satisfying, was the remedy. So even though the zoo was found to violate the Endangered Species Act and was prohibited from continuing to possess the animals in violation of the Endangered Species Act, the district court allowed the zoo to relocate the lemurs and tigers to roadside zoos of its choice, so long as those animals went to zoos that were licensed by the U.S. Department of Agriculture under the Animal Welfare Act. Only 2 judges made that decision, though. The dissenting judge, Judge Richard Goldberg, who I'm showing you a photo of right now because I'm proud of him. He dissented on this point. He also is 91 years old, so I think this is an old photo. He argued that one should look to whether the relocation of the animals fulfills the conservation purposes of the Endangered Species Act, and isn't whether it complies with the Animal Welfare Act, because the lawsuit wasn't under the Animal Welfare Act, it was pursuant to the Endangered Species Act. This makes the most sense to me, it makes the most logical sense, and I think it will eventually win out, but it didn't win out in the Cricket Hollow Zoo case. So as a result, the endangered tigers and lemurs at the zoo are in a better place, but not, in my view, the best place, not in the best sanctuary. And unfortunately, all of the non-endangered animals, like the pigs and the cows who are at the zoo, are still at Cricket Hollow Zoo, which still operates to this day. I wanted to focus on the remedy shortcoming, though, because I think it highlights how we keep building on previous cases to achieve protections that the Endangered Species Act can and should deliver. It used to be that the ESA only applied to wild populations, but now it applies to both wild and captive. It used to be that only people who saw a decline in the number of animals could bring lawsuit, but now we've got people who see an animal continuing to suffer in inhumane conditions able to bring lawsuits. It used to be that the law would only protect animals whose skin or bones were broken or wounded, Now the law is being used to protect animals whose psychological needs are suffering, like the lemurs kept in social isolation. We've overcome all of those obstacles, and I think that we can overcome this remedy problem with our next lawsuit, whichever one it takes. So that's just to say, even with the problems of this remedy in Cricket Hollow Zoo, we have a path forward thanks to Keel v. Selner. It shows that you can bring in an ESA lawsuit to win, and the animal movement has seen the light by winning an ESA case, and we're now trying to spread the good word to other parts of the country. We actually started with the lions at Cricket Hollow Zoo. The lions were not initially listed as endangered. The listing decision came out in the midst of our lawsuit. And so we brought another lawsuit with regard to the lions. And before that, before we even reached trial with that lawsuit, settled with Cricket Hollow Zoo to transfer the lions to sanctuary. The two lions from Cricket Hollow Zoo now are at the Wild Animal Sanctuary in Colorado. I think I'm showing you a before and after here. In addition to the Cricket Hollow Zoo, we're building upon the Keel case in a lawsuit against the Houston Aquarium, which is owned by Landry's Seafood Restaurants. This concerns white tigers who've been kept for at least the past 15 years in the basement of the aquarium where they've never seen natural sunlight. That case is pretty far along. There's been a motion to dismiss, but the court has put the litigation on hold because it has come out that the Houston Aquarium is actually building an outdoor tiger exhibit, as shown here. They're in the middle of construction now, which should provide for the type of relief that we were seeking in the lawsuit. We're also have built upon the Cricket Hollow Zoo in a threatened lawsuit against Deer Haven Mini Zoo in Maryland. We'd focused on the lemurs that were held in captivity there. I'm showing you a photo of the lemur named Mango, who is now living, as a result of settlement from our threatened lawsuit. He is now living in the Endangered Primate Foundation Sanctuary in Florida, along with his partner for life, Strawberry. What's interesting about this case is that the threat of the lawsuit caused the zoo owners, roadside zoo owners, to actually settle for more than the endangered species. They agreed to move all animals that the roadside zoo deemed exotic to sanctuaries of animal legal defense funds choosing. This included Arctic foxes, a family of Arctic foxes, a number of cavies, which are rodent-like animals, a bobcat, and the lemurs. I may be forgetting some others. We are engaged. We've recently filed 2 new lawsuits, Endangered Species Act lawsuits, premised on the Cricket Hollow Zoo theory. One is against the Olympic Game Farm. This is in Washington State in the Ninth Circuit. It's a fairly large drive-through roadside zoo facility where the bears are known for waving at visitors, for visitors to throw bread at them, which my immediate thought there is that this is probably not a generally accepted husbandry practice. So the exemption doesn't apply. The current posture of that case is that the Olympic Game Farm has filed an answer to the complaint, which means that we are going to dive into discovery over the next several months. In addition to the bears, grizzly bears at the Olympic Game Farm, there are wolves, a Canadian lynx, tigers, and lions. And finally, we have recently brought a lawsuit against the Farmers Inn, which is another roadside zoo. This is in Pennsylvania in the Third Circuit. Facts of this case are that It's like a petting zoo slash exhibitor zoo slash restaurant. Includes a lemur named Queen Louise, who is in isolation, a leopard in a dilapidated enclosure, and I'm showing you a photo of a scarlet macaw, which is an endangered bird. And we may be able to bring up the issue of whether the exemption applies because there are no Animal Welfare Act standards that apply to the scarlet macaw. The current posture of this case is that just yesterday, the farmers in the roadside zoo filed a motion to dismiss our complaint. And the judge that we have in that case likes to run on an expedited schedule. So our opposition to the motion to dismiss is due next week, with a reply due soon after that. And I wouldn't be surprised if we get a decision on the motion to dismiss within a month. So I encourage you to follow how that goes. And I will stop there for questions. Happy to talk about any of these cases or any questions you have.
Thank you so much, Danny. That was very good. You can take a breath. That was a lot of talking on your part. I am here with Wesley. He's not leaving my desk, so he's just here for the webinar. Oh, and now he leaves. I swear, he's been here for like 10 minutes, and I'm like, you're gonna be on camera. But anyway, so thank you so much. We will now open it to Q&A. So get those questions in. And while we wait, I have an oddball question for you, if you're open for it.
Okay.
Okay. So there has been talks about de-extinction of species, so bringing species back from extinction with genealogy. Do you think that those species would be covered by ESA?
That's fascinating.
Yeah, I'm not sure. Well, who knows, really? I could kind of see it only because their populations would be so low, they'd be at threat, their environment might not be up to par with what it should be. But yeah, fascinating discussion of what this pit bull of a law could potentially mean for animals.
Sure. So, yeah, I mean, just to respond to your question, I think that you'd want to look to Section 4, the listing provision, and go through all the factors to see whether it applies. And then also there's a section called 10J, which applies to experimental populations for moving animals in captivity. For example, the Mexican wolf. Its population was so low that it was, and the California condor, that they were held in captivity until they reproduced to such a level that they could be returned to the wild. So I think you would want to look to that there for analogies. But I gotta say, the de-extinction thing kind of scares me.
It reminds me of Jurassic Park. That's what my friend and I were just talking about that. And yeah, but it's very interesting to see, they have the genes for certain elephants and other critically endangered species. So it would be interesting to see how this might evolve. Unfortunately, with the way that things are occurring now with climate change and extinction. So, okay, we have some questions. This one's from Tracy. Can you comment on the USDA's own complaint and motion for license revocation on Cricket Hollow Zoo? Hearing with administrative law judge took place 24 months ago.
Yes. Yeah.
So long.
I have an axe to grind. Thank you for that question, Tracy. Yes. So this allows me to promote another of our cases. So the Cricket Hollow Zoo has been very unfortunate for the animals because the animals continue to live in squalor. But it has been a defendant in a number of our lawsuits that set a variety of precedent. And one way that it's set precedent is that the USDA, as it was enforcing the Animal Welfare Act, which is wholly apart from the Endangered Species Act, because the zoo was not meeting the standards of the Animal Welfare Act, the USDA brought an enforcement action to revoke the zoo's license so that it could no longer be an exhibitor. And the administrative law judge, because this was an agency proceeding, found that it didn't deserve to have its license revoked. But the way the process, unfortunately, the administrative process is that an exhibitor can appeal the license revocation to a higher body within the agency, and then to a circuit court, which can take up to a decade. And all the while continue to operate as an exhibitor, continue to make money, continue to exhibit the animals. We have brought a lawsuit to try to intervene in the agency enforcement proceeding. We initially succeeded in that it wasn't laughed out of court. The district court found that we should at least be considered to be an interested person because Animal Legal Defense Fund has, and its members have an interest in the animals there. But then the agency again found a way to exclude us from the proceedings, and that we've challenged that sort of on the basis of on a variety of legal grounds. We've challenged that to the district court, lost there, and we're now briefing that question to the DC Circuit. And should ALDF be allowed to participate in the proceeding, we might try to find a way to push along the agency enforcement action. It's unbelievable to me that that this zoo continues to exist as a zoo, even though everyone agrees it shouldn't, including the agency.
Yeah.
The wheels of justice turn slowly. Yep.
Very slowly. We have had some successes though in closing. Was it King Kong Zoo in Animal Land? Both? Okay.
Yes.
Some successes. I cling to the successes. So Melissa's asking, can you explain the requirements for something to be considered an exhibitor zoo? Do they need to charge for admission to fall within that category, or just have animals on display?
So to be, I think Melissa's asking about to be an exhibitor that's regulated by the Animal Welfare Act.
I believe so, yeah.
Yep, okay. There actually was a recent rulemaking on this question that the zoos have to, or an exhibitor must be larger than a de minimis exhibitor, so that you are exhibiting, I think it's something like more than 9 animals for a certain amount of money. I can't remember what the minimum threshold was. And they shouldn't be household pets, I think. And this was likely a reaction to, there's a really fascinating case out of the 11th Circuit where Ernest Hemingway's house, which is a museum, had, as part of its attraction to come to the museum, had a number of the of cats that were all the 6-toed cats. And people were actually paying for admission to go visit the 6-toed cats, not necessarily just to see it, Ernest Hemingway's house. And the USDA determined that meant that this museum was an exhibitor and needed to be regulated under the Animal Welfare Act. The 11th Circuit agreed with the USDA. And I think for that reason, it may now be exempt as a de minimis exhibitor, but for that, it shows the reach of the exhibition requirements. Sorry to keep going with this, but I think it's really interesting question. You know, I think this raises a question as to whether those YouTube channels. I have a little kid, so I'm now thinking YouTube Kids. But YouTube Kids has exhibitors. They have like a YouTube Pets channel, and where people pay to subscribe to watch celebrities show off animals that they have. To me,
like exotic, including cat-like
animals. There's some folks on these channels that say, "Look at my 20 snakes." To me, that means that they're an exhibitor.
Yeah, if they're charging for the subscription, interesting. Well, going through, we're getting a lot of good questions, so we will try. I mean, Danny, you're good running past 1:30.
I can go for about, let's see. Yes.
Okay, we'll go a little bit past 1:30. We totally understand if you need to to get off. We are recording this, so you can always jump back for Q&A, but I will try to get to as many of these questions as possible. The next one is Catherine is asking, would you touch on how the ESA is being used to fight Trump's border wall?
Oh, I wish I could.
I know.
I wish I could. I wish I unfortunately am not on that case.
Yeah, we
My
do
colleague
have
Tony Ellis is in. Yes, and we have right. I think you were going to say we have a website, a web page about the case. In particular, I think it's like the is it the jaguar or the ocelot is an endangered animal in that area that is, just I haven't looked at the case, but just off the top of my head, I would suspect that the claims relate to, because it's a government agency, right, that would be building the wall. That means both Section 7 and Section 9 could apply, the prohibition on the taking of individual animals. And then also Section 7's jeopardy provision, which would allow for someone to sue the Trump administration, for lack of a better term, for wall building that adversely modifies critical habitat, should there be any critical habitat that's been designated for species in that area, or that could potentially jeopardize the species' survival. But I wouldn't put, and just to go back to the God Squad, I wouldn't put it past the Trump administration to, even if there happened to be a jeopardy finding, I wouldn't put it past them to say, you know what, this wall is more important than the continued existence of certain species.
Really interesting. But I did link the border wall discussion from our website, so everyone hopefully can see that. If not, though, if you can't see the link on the questions, you can go to our website and just in the search bar type up border wall, and all of that docket will come up, and you can see from start to not finish, but from where we are now, we are still trying to fight the decision. The district court did issue a summary judgment for dismissal, so we are fighting it, but we'll see what happens.
And in fact, I'm not sure this is up on our website yet, but we on Saturday, I think it was Saturday or Sunday, filed a new lawsuit to challenge the emergency declaration.
Yay! Awesome. All right, so Emily is asking, I know that in the 11th Circuit, after PETA v. Miami Seaquarium, the circuit court held that harm or harassment is only actionable if it poses a threat of serious harm to the animal. Do you think this constitutes a circuit split that the Supreme Court will eventually have to resolve?
I actually wrote, I knew there might be a question about this, so I wrote
great question.
Well, maybe I'll start by answering what I hope. Not what I think. I hope that there won't be a circuit split because there is still a pending petition for en banc review. And so the 11th Circuit's decision, which as was accurately described, requiring a higher threshold for harm, that, in my view, is very untethered to the statutory and regulatory text, particularly with the view of the Endangered Species Act being so powerful, and a bunch of other case law, as applied to wild animals, that I'm hoping that the 11th Circuit deals with the petition for en banc review by creating a new standard and vacating the 11th Circuit decision, which would then open up, would then mean that there doesn't necessarily have to be a circuit split. I'm not sure that the 8th Circuit's decision, which is the only other circuit that's dealt with the ESA as applied to captive animals, necessarily conflicts with the 11th Circuit decision right now, because the district court decision, well, first, it really just affirms the district court's decision. It doesn't flesh out all of the details of it. The district court really focused on harass, not necessarily harm. And there were a lot of the district court focused on for harm as applied to the tigers, really looked at the number of tigers that had died
Oh.
prematurely.
Mhm.
So it really, I think that's distinct from the you could almost say that a higher level was required. Let's hope that that's
Yeah.
not how that gets interpreted, and that
Yeah.
everybody complies with or follows what the 11th Circuit did. And,
Mhm.
and I'll say that's a reason why we have cases in other circuits now, is that we think that the 11th Circuit decision, as it currently stands, is wrong. And certainly, I don't want there to be a circuit split that makes its way to the Supreme Court at this very moment.
Yeah.
But that may be where we end up.
Interesting. Thank you.
Yeah, good question.
Yeah, really good question. Let's see.
Well, for other folks, that may not be following along with the Lolita case, that's it's a very similar theory to the Cricket Hollow Zoo case. I mentioned that Lolita is alone, is isolated alone in what is more or less a fish tank. And the arguments that the plaintiffs used in that case, including ALDF, were that the conditions of Lolita's confinement were falling short of the Animal Welfare Act standards. Her tank was too small. She was getting it, and she was also suffering harm in the form of sunburn, social isolation, etc.
So our next question is from Rachel. She's asking, how does jeopardy provisions of ESA apply to state as opposed to federal actors? Are there differences, and what are they?
I don't think it does apply to state actors, but please double check me on that. But I don't believe that it does. I think that state actors really then would fall, would only be subject to the Section 9, which in some sense has more teeth than Section 7, right? Because you don't have to look to the jeopardy of the entire species, but really whether the state is through its permitting process. So, for example, I think Strahan v. Cox out of the First Circuit, I'm forgetting the state, but maybe Massachusetts, was a lawsuit that found a Section 9 violation or take prohibition violation when Massachusetts, or whatever state that was, permitted certain fishing activities, and the lines from the fishing activities were harming and killing endangered animals. So I would look to Section 9 first, and then also to state endangered species acts. There are a lot of states that have their own baby ESAs. For example, in the Olympic Game Farm case, we are bringing claims not only under federal law, the Endangered Species Act, but also state law, and in particular the State Endangered Species Act. We're not bringing it against a state actor, but state ESAs do exist.
Perfect. Thank you. So we have one more question, and it's very interesting. I had not considered this question before. I'm sure you have, being the legal mind. But Joanna is asking, okay, so she says, as you mentioned, the scarlet macaw at the end, she did her undergrad thesis on the threat of hybridization of two new formed species of scarlet macaw, but most people ignore species that are exotic pets and don't treat them as endangered species. What is your thoughts on having what would appear to be common pets listed on ESA to do their eradication from the wild in order to feed the pet market? So, if you have a rare exotic bird who's on the ESA, how does that work? Essentially.
Right. I mean, it's just in a sense, it's sort of like it used to be that people had chimpanzees as pets.
Yeah, exactly.
I think I've seen that, and I don't remember if this is the case with the scarlet macaw, but I've seen that certain birds in particular, they get listed often as threatened species as opposed to endangered, and that allows for special rules, and the agencies will often create special rules that say, well, if used as a pet, in this context, maybe it doesn't, the ESA doesn't apply. But it's a concern. It's sort of like, if you have a pet that is an endangered species, first you should really take care of that animal.
Please take care of all your animals.
And second, you might want to hope that no one sees you and thinks to bring a Section 9 lawsuit against you if you're mistreating that animal, because
I'm watching.
I think you could be liable. You don't necessarily have to be an exhibitor to be liable for violating Section 9. And I forget who, Joanna, I think, with this really interesting question. Brings up the pet trade, and I think that really the focus for, as much as I want to be threatening to Joe Schmo who has a pet Scarlet Macaw, I think the real focus for the movement for animal advocates should be looking into what is pushing along the pet trade. So just in the same way that we are trying to bring actions against puppy mills, and we should be looking at the larger industry actors that are pulling these animals out of the wild and decimating them in the wild. And to give kudos to PETA, PETA is doing that. PETA will, if not bring lawsuits, will highlight how entities like PetSmart are engaging in the pet trade of exotic animals that could cover endangered animals, but just really exotic animals, and like, for example, snakes. The number of snakes that die in transit between these various big pet conglomerates or pet store conglomerates.
Yeah. So I did lie. I have another question. If you.
All right, throw it out.
It'll be one last question, I promise. But it was a good one. So I couldn't pass it up. Emily is asking. What? You're like, ask away. Ask me anything. Okay, so Emily is asking, can you comment on why the court in Cool v. Selner didn't award attorney's fees to the plaintiffs, even though they succeeded on their claim? And do you think this may dampen the willingness of plaintiffs to bring claims?
This is another great question.
I know.
People have done their homework.
I'm very impressed by our attendees.
I guess real, what's the word? For, in being a legal realist, I think that the Eighth Circuit didn't want us to win this case.
Okay.
And I think that, but they went along with the law because the law said that the Keels and everyone else needed, had proved a violation of the Endangered Species Act. And the attorney's fees issue was a real travesty because they applied the wrong standard, and hopefully that doesn't set bad precedent for the future. Yeah. And it was, I think, the court contorting itself to not put what were, in some sense, sympathetic defendants out of house and home.
Yeah.
Because the Selners who run the roadside zoo, I mean, they could only afford $7,000 in veterinary fees. I mean, it's hard to tell how much of it was them just not willing to provide care for the animals and how much of it was like not being able to provide care for the animals.
Yeah. And then not finding. Yeah.
The court might have just believed that they couldn't afford to care for the animals.
Okay.
And on the other side of the ledger was an organization that is a national organization that has several $1 million in revenue, providing attorneys pro bono.
I was going to ask about the pro bono. Yeah,
right? With amicus briefs from the Humane Society, which is even bigger than the Animal Legal. And I don't, as of right now, these ESA cases against captive animals, or to protect captive animals, are really only being brought by the larger animal advocacy groups. So, and I don't think that's because of the attorney's fees issue. I think it's because people just haven't, like the plaintiffs bar hasn't figured out this could be an interesting opportunity.
Okay.
And so I'm hoping that there will be new decisions, because we these types of cases, we want to be setting precedent to be the tip of the spear, and bring out the private attorneys general to actually enforce the law against red-tailed zoos. If we get a couple of good attorney's fees decisions, we'll maybe see the plaintiffs bar going after them, which I think is what Emily was suggesting.
Yep. Well, thank you so much, Danny. This was really fun and lots of great conversations. Thank you, attendees. Your questions were amazing. I have a lot to think about. I'm still on that genetics thing. And now pet trade too. Anyway, thank you all so much. There will be a survey at the end of this webinar. Please do take it. We're always looking to improve your experiences. And yeah, thank you so much. We'll be back hopefully in May for another webinar, so stay tuned. And then we'll have our animal law summer school webinars starting in June, and that will be on farmed animals. So also stay tuned for more information about that. But in the meantime, please join me in thanking Danny. Woo!
Right.
There's like mass applause throughout the country now.
Right.
And Australia. We did have some international folks tuning in. So thank you all so much, and we will see you same place, probably same time in a few months. Bye, guys.